the Supreme Court has placed itself above Congress, the Constitution, and the founders. Sheldon Whitehouse, Senator Sheldon Whitehouse, has been a guest on this program many times, just filed an ethics complaint about corruption with the Supreme Court. Weirdly enough, he had to file that complaint with the Supreme Court. He had to send it was a letter he sent with his complaint, and the letter had to be submitted to John Roberts, the Chief Justice of the U.S. Supreme Court, and one of the corrupt members of the court. John Roberts' wife has made over $10 million hustling lawyers into law firms that, might do business with the Supreme Court. He writes, Sheldon Whitehouse, in his letter, he says, I write to you in your capacity both as Chief Justice and as Chair of the Judicial Conference because, unlike every other federal court, the Supreme Court has no formal process for receiving or investigating such complaints. Right. His complaint was started or sparked in part, this White House's complaint, by Sam Alito in the Wall Street Journal saying, and I quote, no provision in the Constitution gives Congress the authority to regulate the Supreme Court, period. Yeah, he seriously said that. Now, you would think that a lawyer on the Supreme Court would be familiar with the Constitution. I mean, they're constantly citing the Constitution when they make it harder for people to vote, or when they make it harder for women to get abortions, or when they allow religious freaks to have their way. But apparently not. Apparently Sam Alito does not know that Article 3, which establishes the court system, Section 2, which establishes the Supreme Court, says, quote, the Supreme Court shall have appellate jurisdiction both as to law and fact, with such exceptions and under such regulations as the Congress shall make. Right. So what do we do about this? There are a number of possible solutions here. And, I think probably one of the most important would be to say that the Supreme Court, from now on, if they want to engage in judicial review, if they want to strike down laws that have been passed by Congress and signed by the president, which arguably contradicts the traditional understanding of what the court can do prior to 1803. I mean, seriously, the court has been doing this for a long, long time. It's just that in the last 100 years or so, it's become pretty much all they do. Well, what I'm arguing is that Congress can regulate that. Congress can say you may not rule on constitutional issues unless your ruling is unanimous. That would end the 5-4 and 6-3 decisions. And it would mean that the court would only be issuing constitutionally based decisions when there's complete agreement across the entire spectrum represented on the court about the issue. Every decision would become, that affects the Constitution, would become 9-0. Now, the court would still be the court of last resort. They'd still be able to do a 5-4 decision about, whether, Nike defamed Adidas or something like that. I mean, it's just, whether Donald Trump is going to sue E. Jean Carroll. Those kind of things, those normal final court of appeals. I mean, that was envisioned as the main job of the Supreme Court back in the day. And they'd still be able to do that with simple majorities. But if they want to rule on something that has to do with the Constitution, to say, well, we think the Constitution says everybody should be able to have a gun, or we think the Constitution says women shouldn't be able to get an abortion, or we think the Constitution says that it's okay if North Carolina, South Carolina want to make it hard for black people to vote. If they're going to try that, it's got to be unanimous, number one. And number two, and we've discussed this before, but I think it's worth discussing again, expanding the court. During the founding generation, after John Adams lost the 1800 election, the election of 1800, Dan Sisson and I wrote a book about this called The Revolution of 1800. Or Dan wrote the book, and I did a light edit on it. John Adams and his Federalists during the lame duck session in 1801 passed the Judiciary Act of 1801, which cut the size of the Supreme Court from 6 down to 5. Why? Because Jefferson was coming in as president on the backside, And Adams did not want Jefferson to be able to add anybody to the Supreme Court. But Jefferson brought with him a huge majority of Democratic Republicans for both the House and the Senate, and they just, basically reversed Adams's law and went back to 6. Then in 1863, Abraham Lincoln wanted to get a vote on the court against slavery. He wanted to reverse Dred Scott. He actually ignored Dred Scott, but he wanted to reverse it. So he got Congress to increase the number of Supreme Court justices all the way up to 10. Yes, 10. We've been there. 2 years later, Lincoln was assassinated, and Andrew Johnson became president. He was a slaveholder. And Congress did not want Andrew Johnson to be able to appoint a Supreme Court justice, so they passed a law lowering the number of justices on the Supreme Court from 10 down to 7, just to deny Andrew Johnson an opportunity to fill a vacancy on the court. After Johnson left office, Republican President Ulysses Grant got Congress to increase the size of the Supreme Court back up to 9, which is where it has remained ever since. But, the bottom line is we have a long history of making changes to the number of people on the court, and I think we need to be doing it. So the Saudis and Putin are gambling on a Trump win. Here's how they're manipulating the election. We'll talk about that on the other side of the break. Also, some good climate news. This is interesting. I think the Biden administration, after approving the Willow Project and getting enormous blowback, has decided to do the right thing, or at least with regard to some of this. I'll tell you about that on the other side of this break. And we'll be taking your calls. Stay with us.